Okay, it says I'm live now. Let's see if that works. I don't know. I'm getting the same kind of a red window that I got the last time. Well, we'll see. Thank you, Sharina. I appreciate you bearing with me while I stumble through this Facebook nonsense. So, welcome Facebook Live. If you're just now getting this video feed, I'm not exactly sure what's happened here, but I am Jeff Vastola, and this is Vastola on the Law. We're about halfway through the show, but feel free to type in a question of your own if you're watching on Facebook Live. Today, my topic is the issue of subrogation, which is when insurance companies have a right to be reimbursed for benefits that they've paid when you recover from some third party, and that would include, of course, Medicare or Medicaid. So hopefully everything's working now. I do have more cases to talk about. If you have a question of your own, please interrupt me. That's the purpose of the show. I want people to call in with their issues. I don't want to just be spouting off about my issues. But in the meantime, I did want to follow up. Last week, I believe it was, maybe the week before, I was talking about how I had recently gotten back into the courtroom and had a jury trial about 3 weeks ago up in Vero Beach now, and the issue of jury selection. That was something that I was talking about for folks that have never been through a jury trial or jury selection. It's a pretty interesting process, and a new case came out, which is really just kind of emphasizing the law as we already know it. But this is a case called Alejandra Rivas versus Alicia Sandoval. It's based out of 3rd District, which is Miami, 3rd DCA down there in South Florida. And essentially what happened was, during the jury selection process, a potential juror responded to questions to say, I'm not so sure that I can be fair to both sides because my son was sued because of a car accident, and he ended up getting $100,000 from my insurance company, and I don't think that he was that injured because, you know, my son told me what happened at the scene, and the other guy was walking around. The other guy told my son that he was okay, and I just don't think that that was right. And so what happened was, during questions from one lawyer or the other, I don't know exactly which one, he demonstrated some bias. He demonstrated perhaps an inability to be impartial. And so what happened was, the other attorney, which would be the defense attorney, tried to, what we call, rehabilitate the juror by asking some follow-up questions to say, well, we heard what you said earlier, but, you know, don't you think that you can be fair in this case, and don't you think that you can listen to all the evidence and be objective in this case, and so on and so forth. And when the parties tried to select the jury, the plaintiff filed a motion to excuse this particular juror for cause, and the judge denied it. And I guess the plaintiff's lawyer was out of peremptory strikes or something, because this guy ended up on their jury. So he could have used a peremptory to get rid of him, but you only have so many peremptory strikes, and so I suspect that maybe the plaintiff's lawyer was out of peremptory strikes, using them on perhaps more important jurors that he needed to get rid of. And so this juror ended up on the jury. They had probably about a 1-week jury trial, and the plaintiff lost. And after the case was over, after everybody spent all of that time and effort in a 1-week jury trial, the plaintiff filed the appeal because the plaintiff lost. And this is what happens. This is an appellate court decision. This is a higher court reviewing everything that happened in the lower court and going all the way back to jury selection on that very first day, when the plaintiff tried to excuse this juror for cause that ended up on the jury. The appellate court said he never should have been on the jury. He should have been stricken for cause, because as soon as a juror tells you, I don't think that I can be fair, I don't think that I can be impartial, because in my life's experience, this is what has happened to me, and so I'm, in a sense, tainted, or that's the way I'm bent, then you really can't rehabilitate that juror, no matter what the juror may say afterwards. So, interesting case. I find it interesting anyway, because it's just kind of what I do. But yeah, the law in Florida is that, you know, you can't unring the bell. You know, that's a, boy, this mosquito's driving me crazy. You can't unring the bell, which is something we learn in law school. And another one that I've heard recently that I really like is that you can't put the toothpaste back in the tube. Once it's out there, it's out there. And typically what people say the first time is how they honestly feel. And then, of course, you can try to, you know, guilt them or persuade them into being more politically correct. But what's truth is truth. So thank you all for listening, and thank you for watching. I'm seeing some people telling me that they can finally see me on Facebook Live. Good morning, Mom from Tennessee, and good morning, my beautiful wife from upstairs. And anybody else that's watching, if you have a question of your own, please call into the show. The number here is 877-850-8585. I've got a few minutes left, perhaps time for one question if you want to call in. If not, that's okay, because I have more to talk about. My next case for discussion is, again, coming from the Florida Law Weekly. This is a case of Hernandez versus Mishali, which is out of the 3rd DCA, again, down in Miami. What I found through reading through these week after week after week after week is that oftentimes they're overloaded with one or two DCAs, and so I don't know if there's like a cycle of opinions, but anyway, that's why a lot of these opinions in this particular issue are out of the 3rd DCA, because it happens to be that edition. This was a case that talks about, in law, in Florida, there is what's called a presumption of negligence. If you're driving an automobile and you strike somebody from behind, you are presumed negligent. Now, there's a difference between a presumption of negligence and an assumption of negligence. The assumption of negligence just simply doesn't exist in the law. But when there's a presumption of negligence, that works against you if you're the one driving the car that causes the accident. But it is what's also termed a rebuttable presumption, in that if you can prove in one way or another that you weren't really negligent and what happened was not your fault, then you can overcome the presumption. And then at that point in the courtroom, in front of the jury, it becomes a level playing field. But if you can't overcome the presumption, then the presumption of negligence in Florida dictates that the judge is going to instruct the jury that the defendant was negligent. So then, therefore, that question gets removed from the verdict form so that the jury doesn't get a chance to answer that question. Typically, the defendant wants that question on the verdict form because the more questions the jury has to answer, and they have to answer every single one of them in the plaintiff's favor in order for the plaintiff to win. So the more questions they can put on the verdict form, the better the chances that at some point the jury's going to say no. And as soon as the jury says no on the verdict form, that means that, for that particular issue, that the plaintiff has not won, has not prevailed, has not met the burden of proof. So the presumption of negligence can work against you, and I use it all the time when I represent plaintiffs in rear-end automobile accident cases, because most often rear-end auto accident cases happen because people are not paying attention. Most frequently these days they're on their phone, although very few times do people actually admit that. They're looking down, they're looking at the radio, they get distracted. You all remember the Far Side cartoons with the bee in the back seat. The things happen, people get distracted, and accidents happen. We know that. But when things happen that are not somebody's fault, then that presumption of negligence can be overcome. Okay, and then all of a sudden, again, it's a level playing field in front of the jury. The question gets put back on the verdict form: was the defendant negligent? And there you go. So in this particular case, what happened was the defendant tried to convince the jury, and ultimately the judge, that he wasn't negligent even though he caused a rear-end automobile accident, because at the time of the crash, he had been suffering from some kind of a seizure. And that is the law in the state of Florida. I mean, if you are having some kind of a medical condition and you lose control of yourself through no fault of your own, then you can overcome that presumption of negligence. But in this case, it almost seemed concocted. And so the trial judge heard all the evidence from the defendant. The defendant's girlfriend was in the car, and she kind of explained everything was kind of, I think, going along with the testimony. But ultimately, the judge said, this is not enough. I'm not going to suggest to the jury that you have rebutted the presumption of negligence. And then the case went forward, and the verdict was entered, and the case was over. And then what happened was there was a new judge. Apparently, maybe the case happened right at the end of the year when a judge was being transferred out. A new judge came in and looked at all of the evidence that had been introduced, but was not there during the trial. And that judge says, I think that was enough to rebut the presumption of negligence, and so therefore I think it should have been a level playing field. I think that the jury should have been asked the question on the verdict form, was the defendant negligent, instead of being instructed that in fact the defendant was negligent, and that judge reversed the verdict in a post-trial motion. So then of course the plaintiff appealed that, and the appellate court, which is a higher court looking down on the trial court level to say, okay, what happened, was there any mistake, said that was a mistake of the incoming judge to step into the shoes of the judge that was there in the trial and second guess that judge's determination that the presumption was not rebutted. And that's because a lot of things happen during a jury trial that are not observable from a transcript. You know, there's a lot of mannerisms, there's a lot of inflection in the way people respond to things. Sometimes there's a very long delay when they respond to a question, which is, these are all indicators, you know, of people that are perhaps not being truthful or being careful with the way they're answering a question to make sure that it lines up perfectly with, you know, whatever they've concocted. So anyway, very interesting case, at least in my opinion. And apologize because my screen went blank on me, but we're just about out of time. I only have a couple more minutes, but if you want to reach me privately on my cell phone, that number is 833-827-8652. It's 833 Vastola. I know a lot of people don't like having to figure out what number corresponds with the letter, but if you can remember 833 Vastola, that is a 24/7 hotline directly to me. It forwards to my cell phone. So if you have anything you want to talk about, then please do. Thank you all for watching. Don, nice to see you this morning on Facebook Live. I'm sorry it took me about half the show to get it right. I don't know why it's doing this to me, but we'll figure it out. Let me see what else to talk about. If you want to go to my website, that's vastolalegal.com. I do have more cases, but I'm just not sure if I'm going to have time to talk about them. Sovereign immunity. That's a case that popped up in this one. And maybe I'll make this my topic for next week because I can't do it justice in just a couple of minutes. But in the event that you were not aware, up until about the 1970s, the state of Florida and its agencies and subdivisions had complete immunity if they were in any way negligent, or the employees that work for the state agencies or subdivisions were in any way negligent. Then there was complete immunity. There was nothing you could do. There was no lawsuit to file to seek compensation. That was called sovereign immunity, which we take from our English ancestors, who, the sovereign referring to the king. The king had, and probably still has, complete immunity, similar to the way the government did. But a statute was enacted, and I believe it was in the 1970s, at least that's the first time I see it being active in our Florida statutes, where that immunity was lifted to an extent. And from the early 1970s until 2011, the immunity was lifted, but then was capped at $100,000. And the attorney's fee is also capped at 25% as opposed to 40%. This is a Florida statute that you can go look at if you want. It's Florida Statute 768.28. And it gives you all of the conditions precedent that you have to follow in order to file a lawsuit against the state agencies or subdivisions. You have to give notice in writing, and keep in mind that you've got to do that within 3 years. Now, a negligence action in the state of Florida has a 4-year statute of limitations. People fall into a trap often in that, if they're not aware of Florida Statute 768.28 and its conditions precedent, then they don't put the defendant on notice within 3 years, which is what's required in the statute. So even though Florida Statute 95.11 says you have 4 years to file your lawsuit, Florida Statute 768.28 says, yeah, but you have to notify the state within 3 years. And if you don't notify the state, then you haven't satisfied all of your conditions precedent. And when you go to file your lawsuit after 4 years, or just before 4 years is up, the trial court says, sorry, you waited too long, you didn't give notice, throws out your case. But anyway, I'm going to be talking in more detail about Florida Statute 768.28 next week, so that you can find out more about sovereign immunity. Like I mentioned, in 2011, the statute was amended finally, so that the cap is now $200,000 as opposed to $100,000. I have a bone to pick with that, because frankly, the statute should be revised more frequently than just every 40 years or whatever it was. And it has not kept up with the cost of living. You know, typically there's a 2 to 3% increase every year for cost of living increases, and going from $100,000 in the 70s to $200,000 in, you know, after 2010 has not kept up. I did the math, probably very poorly, but according to my math, the cap should be somewhere around $500,000 right now instead of 200. But what are you gonna do? All right, well, I'm out of time. Again, remember, 833 Vastola if you want to reach me anytime. That's 833-827-8652. Please don't be offended if we speak or if I send you a message to say, hey, please call the radio show, because that's a great question for the show. But I do try to get back to everybody that calls, so thank you so much. And until next weekend, Sharina, I want to say thank you to you and all your help. Appreciate it. And Sharina's up early with me every morning on Saturday morning, doing a great job. And everybody have a very safe, happy, and wonderful Memorial Day weekend. God bless. Bye-bye.